This is Law Bytes, a podcast with Michael Geist.
For the first time, countries are banning Grok, Elon Musk's artificial intelligence chatbot, accessible through his social media platform X. Pressure has been growing globally after users began prompting Grok to make sexual deepfakes, editing photos that people post to remove their clothing and put them in explicit poses.
It's happening to average people, and not just women. It's also happening to children.
Malaysia and Indonesia have now banned Grok entirely. Britain is also cracking down with a new law that makes it illegal to create intimate images without consent, and for companies to allow that to happen on their platform.
They are not harmless images. They're weapons of abuse. The platforms that host such material must be held accountable, including X.
Welcome back to the Law Bytes podcast. This is the first episode of 2026, and much has happened in the first few weeks of the new year. The government has asked the federal court to withdraw its order to ban TikTok in Canada. The Competition Tribunal has issued a major decision involving Google and private actions. There is speculation about new privacy and social media bills, and the world has been focused on the creation and distribution of AI-generated sexualized deepfakes by Elon Musk's Grok AI. I plan to cover all of these issues and more in the weeks ahead, but we start this week with Grok, which is notable for weaving together online harms, privacy, AI regulation, and platform regulation into a single issue. To help understand what's taken place and Canada's law and policy options, I'm joined on the podcast by Professor Heidi Tworek. Professor Tworek is the Canada Research Chair and Professor of History and Public Policy at the University of British Columbia, where she also directs the Centre for the Study of Democratic Institutions. Her work explores how new communications technologies affect democracy in the past and present, and she served on the government's Online Harms Advisory Board. Heidi, welcome back to the podcast.
So nice to be here. Thanks for having me, Michael.
Yeah, no, it's great that you're back to kick off the podcast series for another year for 2026. And, as I was thinking about different issues to talk about, there's been a lot happening, but this issue around Grok really, I think, is a perfect one to get started, given that it touches on so many different issues that I tend to focus on. And while Grok may not be a household name, the Elon Musk chatbot certainly did attract global attention earlier this month when it was being used to create and disseminate sexualized deepfake images. In plainer language, it was using AI to create explicit fakes of individuals without their consent, which began to actively appear on Twitter or X. Now, I think there's a lot to talk about the Canadian response, or in some instances, non-response, whether it's about internet regulation, AI regulation, or online harms. And I hope we can do all of that. But before we do, for those that really weren't up to speed, what is Grok? What does the service do? And how does Grok differ from some of the other AI services that may produce image generation?
So Grok is basically a chatbot image generation service that is tied onto X, that was formerly known as Twitter. So essentially its knowledge base is all of the posts on Twitter and X that it then uses to, alongside other data, create chatbot responses and then image generation as well. So it was launched after Elon Musk bought Twitter in late 2023, early 2024, and has gone through subsequently multiple versions and updates. So you can use it either through X itself or as a standalone website or app. And there are slightly different capabilities, particularly related to the issue we're going to talk about today, depending on which one of those you use. A couple of other things I think to say about Grok. One is that when Elon Musk was creating it, he was explicitly positioning it as something that he claimed would be not woke, unlike something like ChatGPT. And it's perhaps also important to note that Musk was involved in the early stages of OpenAI, and Grok is, I think, part of his overall beef with OpenAI to try and create an alternative. Musk claimed that Grok would have to be, and I quote, maximum truth seeking, which in his version is also about what he deems to be political neutrality. There have been lots and lots of controversies around Grok. This is only the latest in a series, including claiming there was white genocide in South Africa, anti-Semitism, seeming to overly cater to Musk's views or be overly sycophantic about Musk as an individual. So what we're talking about today is really the latest in a series of controversies around Grok. And I'll just add that there continues to be more and more that unfolds here. For example, a Center for Countering Digital Hate study that just came out thinks that in 11 days between late December of 2025 and early January of 2026, approximately 3 million of these kinds of sexualized deepfakes were created in just 11 days.
Wow. And I think it was that data point that really started to attract the attention of the public, certainly of governments and of regulators, when they sort of began to appreciate just the scope of the issue. Can you talk a bit about how some of the countries did respond to it? Because I think we saw a pretty wide range of responses from different countries as this issue began to take hold.
So if we take a global view outside the US, I'm going to put them into four main buckets of responses. So the first was really countries within Southeast Asia, Indonesia, Malaysia, and then the Philippines, who all banned Grok for this behavior, which has ultimately now resulted in the last few days in Grok saying it will geo-block these capabilities to create sexualized deepfake images. And now the Philippines has come out and said they will then allow Grok to return. So that was bucket one. Bucket two, the Europe, UK, Australia bucket of using existing regulation to pursue investigations into Grok and indeed into X to see what was warranted. I'll say that Musk reacted most strongly to the UK discussing Ofcom, its regulator, launching an investigation, Musk calling the UK fascist for wanting to undertake this. Third bucket, trying to summon X's reps and get something through voluntary cooperation. That was the Japanese response. There's an AI Promotion Act in Japan, but that's really all voluntary cooperation, so no penalties for misusing AI. And then the fourth bucket, I'm going to say the not really doing anything particular bucket, and we're going to put Canada into that one.
Okay. All right. I want to come back to Canada in just one sec, but you highlighted a little bit Elon Musk's response, let's say in the UK. Can you talk a bit more about how the company broadly did respond to this? This evolved over several weeks as the issue kind of took hold. What was their response as we started to see increasing amount of concern from various governments and certainly users as well?
So initially, a lot of the response was denial from Musk that this was a problem. Then there was the accusation that this was censorship, despite, I would say, the vast, overwhelming majority of individuals, when they are surveyed, saying how much they do not want to see this kind of content. Then we've started to see now compliance with, ironically, not the more kind of legally guided investigations, but rather the very swift bans instead. So we've seen a very geographically differentiated response. And the final thing I'll say is just for those who don't regularly try to ask X for comments, that whenever news organizations try to get comments on anything, they receive an automated reply that just says legacy media lies. So it's always a little bit difficult to get insights into the thinking within X, because we basically have what Elon Musk says, and then that's about it.
That's true. Although I suppose it's also the case that action speaks louder than words. And as you point out, where faced with the prospect of an actual block, the company did take some action in jurisdiction. So it's clear that there is a line that if the regulators go across that, the company will have some sort of response. Now, you put Canada into that fourth bucket of not doing very much or not doing anything at all. There had been some reports or speculation at least, that Canada would join some other countries, potentially banning Grok or even X, I think was some of the discussion. But the AI minister, Evan Solomon, quickly tweeted that wasn't on the table. So I want to talk a bit about what Canada could or couldn't do to address the issue. Why don't we start with that notion of blocking? You mentioned that some countries did it, and it proved fairly successful, at least in terms of a response from the company. From your perspective, is there anything under Canadian law that might have allowed Canada to take that route to say we're just simply going to block the service altogether?
Yeah, I'd be interested in your opinion as well. But as far as I can see, not really. And I will say that there have been long discussions over the last few years, as we have had debates about how to regulate regulate the online environment, this has actually been one of the key sticking points, is to say, is blocking something that we would allow in Canada as a last resort if companies don't comply? And there's been, I think, a lot of discomfort with the idea that this would be the final resort, in part because for a long time, this has been more the resort of non-democratic countries.
Yeah, no, I think you're right, and that was my take as well. That notwithstanding the speculation that Canada might try to do something like this, it wasn't at all clear to me that we had any sort of power to be able to issue that kind of ban, much less find a way to actually go ahead and implement it. What the government did respond with was that they said, well, we are at least concerned with the issue around sexualized deepfakes. And so that was where they turned, focusing less on the platform, more on the individual user. And I think that was somewhat consistent with what Musk was talking about. He was saying, well, we're concerned with the users. If the users are doing this, we might kick them off the platform. But so the government's emphasis was that they could at least address the issue, or trying to address the issue, with Bill C-16, which was a recently introduced piece of legislation. Can you talk a bit about what it might do, and whether or not, if enacted, how far would it go to address some of the concerns that arose?
Yeah, so Bill C-16, I would say that addressing non-consensual intimate images is only one small part of this much broader bill, which also addresses things like intimate partner violence, et cetera, et cetera. But that's just to lay that out a little bit more broadly. So it's really, from my read for this particular issue, trying to cement this more in the criminal code, amplify the penalties. But as you say, the issue with it is it's really addressing the individual users, and it's not really about the things that platforms do that enable this to occur. It's not thinking about how do you get platforms to take these things down? What about if you have offenders outside of Canada? There's an onus on somebody to actually report this in some way. And then finally, that the bigger question is whether the criminalized response is going to be the most effective, given lengths of time, et cetera, et cetera. Maybe you catch a few people, but is that really going to be a deterrent to others? When we've seen a volume of this scale, millions, 3 million in 11 days, is C-16 going to be able to deal with that? I'm uncertain.
Yeah, well, I think it's a bit of a giveaway that it's not going to be able to take hold in terms of addressing the full scope of the problem. That's the federal response with respect to sexualized deepfakes. Can you talk a bit about what we've seen at the provincial level? Because I know there has been discussion that some provinces have taken action on this issue, and some with arguably more effective responses than what we're seeing at the federal level.
Yeah, so the one that I know best is British Columbia, where I'm obviously based. And in 2023, the BC government introduced the Intimate Images Protection Act, from my read from afar, in part because they'd been waiting so long for federal government response, and that had not been forthcoming, and the province really wanted to do something about this issue. So in this case, there's I think it was maybe three prongs alongside the criminal code aspect that could be pursued federally. The first is a civil resolution tribunal to try to wrap these things up a little bit more quickly than if you're moving through the courts. The second is creating easy online processes for removal. So rather than victims having to navigate every single platform by themselves, this act is trying to help them by making those processes for removal a little bit simpler, take the burden off of victims. And then thirdly, there's an intimate images protection service that can provide support. So again, helping victims navigate this, because so often there's obviously the initial trauma, but then there's the re-traumatization of having to go and ask for these images to be removed. And we also know that, unfortunately, this isn't just something that occurs immediately afterwards, but sometimes the images are stored elsewhere. They will resurface, in some cases, sadly, even years or decades later. So this can be something that follows people throughout the rest of their lives. And by having an intimate images protection service, you have someone you can go to for fairly easy support. So the reports thus far on this has obviously now been in place for a couple of years, indicate that the volume of people has not been particularly great. So we've had a few hundred cases go through this civil resolution tribunal route. We don't, as far as I know, have public numbers on how many people have contacted the Intimate Images Protection Service. But so far, it hasn't been subject to the problems people worried about, like too great a number of people using the CRT process. It doesn't seem to be overwhelmed, but it's also giving people finally somewhere to turn in these moments when difficult things happen to them.
Yeah, no, it certainly does sound like it offers some promise, and it's often the BC legislation that's pointed to as being a potential model for others to follow. There was one other response in effect. It didn't come from the government, but it did come from the Federal Privacy Commissioner, who was already investigating Twitter on some privacy related or X on some privacy related issues. And that office said it would expand that investigation to cover this issue. Uh, there's, of course, been much talk now for years about potential privacy reform. Should we hold out much hope that the current privacy law can do much about this issue?
I mean, I think we learned from the Cambridge Analytica investigations that there are problems, right? One, it takes a very long time. Compare that to how quickly the bans got results, I'm sad to say. Two, that in terms of what the investigation reveals, that can actually be helpful, right? I mean, people's awareness was very much raised by investigation into Cambridge Analytica, so to give a sort of positive spin on it. But third, that there's no administrative monetary penalty, right? So unlike, say, the UK, here there can be investigations, but no penalties. And so there's a question of what that really then does beyond some level of transparency. But again, given the amount of time this might take, it's unclear how useful that is in this context.
Yeah, no, certainly the timelines for privacy investigations have been very long. I mean, we've seen that with some of the outcomes, whether it's with respect to Google or TikTok, and so the hope for some sort of immediate action you often won't find it, at least to date. It doesn't seem like you'll find it with respect to privacy investigations or using Canada's existing privacy laws. So I wanted to shift gears just a little bit to online harms. And you served on the government's advisory board on online harms. As most listeners will know, the resulting Bill C-63, died almost exactly a year ago with prorogation. So I guess it does beg the question whether or not C-63 in that form would have addressed this issue. Would it have provided someone with the power to address it? Was this particular kind of problem covered by that legislation? And of course, this is relevant not just for what the government was thinking of under C-63, but there has certainly been speculation that we will see some kind of online harms legislation resurface in 2026. We don't know the details yet or how much of a priority it is, but there's a sense that something is coming. And so then it will, I think, surely raise the question is whether this kind of use case would be covered by whatever legislation the government introduces.
Yeah, so just to remind readers who have not reacquainted themselves with Bill C-63 recently, you might remember that its framework in many ways was a duties model. So lots of different duties that platforms were supposed to enact, digital safety plans, et cetera, et cetera. And there was one duty which was named the duty to make certain content inaccessible. And it only relates to two types of content. One, content that sexually victimizes a child or re-victimizes a survivor. Two, non-consensual intimate images. Both of these are covered by this Grok example, right? So I can't see how a C-63 wouldn't have applied to this. These are the two categories, the only two where the content had to be made inaccessible. All of the others were about, what can platforms do to make it less visible, blah, blah, blah. So I think they both apply. In terms of what the bill foresaw, there would have been several paths to go down, right? There would have been the Digital Safety Commission or Digital Safety Office. It could have compelled information from a platform. So you couldn't have just done legacy media lies. You would have had to provide information, could have ordered takedowns, theoretically, of this material. And then under non-compliance, there was the provision of administrative monetary penalties. So that's unlike the Privacy Commissioner's situation. And these would have been greater of 6% of gross global revenue or $10 million, or something more serious, and maybe we would argue to sort of fall in the more serious category, up to 8% of gross global revenue. So I think this would have absolutely applied to this case.
Okay, so we would have had, if this becomes legislation or if it gets reintroduced, at least with respect to those provisions, we would have both an agency or a department that is in a position to seek to enforce with this particular kind of situation covered by the legislation and some real penalties associated with it. I do want to clarify, though, that consistent with that earlier discussion around blocking being the most effective tool, I don't think the legislation envisioned blocking. It envisioned instead using some of the kinds of tools that you just identified.
Yep, exactly. Blocking isn't part of it.
Okay, so we would not be in the doing nothing bucket amongst the four that you talked about earlier, but we also wouldn't be at the other end of the spectrum of moving to block the service altogether. It would have followed this sort of investigative process, but with some real tools at the end of the day that might have resulted in some kind of action. And as you point out, the ability for a company to simply refuse to cooperate or not even try to answer any questions would have been off the table, or at least would be subject to some potential penalties if they did so.
Yeah, and one other thing, I mean, this would have also created some possibilities for cooperation, right? Like we haven't seen, in this particular case, we haven't seen the EU, UK, and Australia come out and issue any joint statements, but at least theoretically, if Canada had some sort of legislation that, was ultimately somewhat aligned with all of those, you could have foreseen actually something where all four of those jurisdictions had some sort of joint process, right? That all of them sticking together might have in some way been more effective. So anyway, that's just another thing to add there.
Yeah, no, it's certainly worth raising. So that points to one avenue that might be used to address some of the regulatory shortcomings that we have to deal with the issue. The other, of course, is AI regulation, and that in some ways has been the issue that has been probably most talked about over the last number of months. It's the area that might seem to fit, given that we're talking about an AI service. What might AI regulation do in this case? And given that we've got real world models, the EU AI Act, which really served as the model for at least Canada's first proposal when it came to AI regulation, although I recognize the government does not appear to be inclined to follow that model with sort of future action. What do we know about how effective that approach might be in addressing some of these issues? It's less about the images, now more about the service itself.
Yeah, so I don't think we've really seen that the AI Act is helping the EU out in these kinds of cases. And that's maybe for a couple of reasons. One is that the main act where the EU has been interacting with X thus far has actually been the Digital Services Act. So the European Union did issue a fine of $120 million against X for not complying with the transparency requirements of the Digital Services Act. But that alone already inspired some very vituperative responses from Musk, but also from Trump, including, mixing in tariff threats, et cetera, et cetera. And so what I think that shows us is that even when you have regulation on the books right now, and it's not actually at all the fine related to content moderation, but rather lack of transparency, you're still getting very strong, responses from the US president. And that potentially that means that enforcement is going to be the issue too. Even if you have the regulation, are you actually able to enforce it? And then finally, will you perhaps back down on that because the threats of other tariffs against other industries are things that some governments politically weigh as more important? And then the final thing I'll say on this issue is that, at least from my perspective, I'm not sure we always need to reinvent the wheel. A lot of the problems that we're seeing with AI are often accelerations of older existing problems. Deepfakes already existed. The BC legislation was developed before we have super widespread adoption of chatbots. And so if we fall into the trap of saying AI is new, so we need new regulation, it's going to be 5, 6, 7 years down the road, potentially before we get anything. Why don't we think about A, what do we already have on the books? B, what have we already developed, like C63, that actually is very applicable to something like a chat GPT, which is also a form of platform. I find that to, I think, be a more practical and pragmatic approach, while, as I say, also recognizing that even the jurisdictions with regulation, actually enforcing it seems to be the big problem right now.
Yeah, no, and that's in many ways the age-old issue when it comes to so many of these issues. You can go around the world to find many expertly written pieces of legislation on a whole range of digital related issues, and where they often fall short is on the enforcement side. And so, if you can't enforce, just how effective is the legislative tool itself? I mean, there's real questions about that. In some ways you provide a really good segue to where I wanted to wrap up with this, and that is, you've done a really nice job highlighting the whole range of different ways that we might address some of these issues. And I think this will ultimately raise the question of, well, what ought we be doing? I mean, Canada found itself in a position in that fourth bucket, as you said, of not doing much, in part because there really weren't many legislative tools or regulatory tools to use to try to respond. And so it does beg the question, if you're the government now thinking about some sort of revamped digital policy. We've seen them backtrack from a number of the prior issues. And as they start thinking about, well, what do we prioritize now? I think it's not hard to envision this being one of those issues. The question then becomes, okay, well, which of these paths do they prioritize? And so if it was up to you, if you were back on another advisory panel, what would you be prioritizing in an effort to deal with something that it feels like on a universal basis, everybody would recognize this is a real issue. We ought to have some kind of tools to be able to deal with it.
Yeah, yeah. So I think ideally, in an ideal world, there's plenty that we can do, even if in this very difficult political environment, right? So victim support services like we see in BC, why can't that be federal? I just don't see any reason why the US would object to that politically. So why not expand something like that? The second would be building on Carney's speech just this week in Davos. Let's get the international coalition who all seem to care about this issue we saw, but they're all moving independently. And Carney has just critiqued that. Here's an issue where we could really build something like that. And it can go beyond, Europe, UK, Australia, right? We've got the Japans, the South Koreas. I think there's plenty of places that would really care about this kind of issue. And then we can see what regulation seems to be feasible, right? And recognizing that the feasibility of regulation is at this moment so tied to CUSMA negotiations in a way that it simply wasn't before. So, the idealist in me would love to see some sort of revised version of C63 passed, but the pragmatist realist is more pessimistic, especially given the Carney government's signals over being willing to backtrack on things like the digital services tax last summer in order to try and get more favorable conditions in negotiations with the US government. I hope that it won't be true, but I fear that this is one of the issues they're willing to bend on to keep other industries more tariff-free.
Yeah, no, that might be the case. I mean, I guess my sense or hope is that they may backtrack on some of the legislation that I was pretty critical of, and I thought, weren't as well grounded from a policy perspective in terms of where we're going. But that doesn't necessarily mean there is no appetite for some kind of regulation. And you're right. Carney certainly seems to be a pragmatist on some of these issues. I don't know that means a total hands-off approach. One would hope that's not the case. And in many ways, I think you've done a nice job as we talk about the Grok case, which really does crystallize these issues. One of the things that's often hard to garner political support around some of these issues is that the discussions tend to be about theoretical or hypothetical issues. Here's a real world case where everyone is going to agree we need to have something. You've done a nice job as we walk through it about the limitations of some of the proposals as well as where there is some real opportunity to act.
Yeah, and I think you're right. This case is so egregious and so terrible if we think about the huge number of people who are harmed by this, not just over the last few weeks, but as I say, because so many images get stored elsewhere, these could be resurfaced throughout the rest of their lives. And my hope is that that is as clear to people in the Carney government as it is to all of us sitting at home, and that it will spur them to recognize how thoughtfully a lot of us have engaged on these issues, precisely to make sure that this is not going to be over deletion, et cetera, et cetera. And that's why these were the two categories, right? Exactly these two. So my hope is, as you say, that we build on what's already been done, but maybe introduce some other parts, I say, like that we've learned from BC and elsewhere, and most importantly, put it into an international coalition, because I think that read of how we're actually going to be able to have any kind of leverage against these major platforms is going to be through a broader coalition, not just single countries trying to deal with it.
Okay. Well, you know what? You've done some exceptional work on this for a number of years, and it's great when you're able to bring all that together on this issue here. So thanks for the work that you've been doing, and thanks so much for joining me on the podcast.
Thanks for having me.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. That's LAWBYTES @pobox.com. Follow the podcast on Twitter @LawBytesPod, or follow Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe at iTunes, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the LeBoy brothers, Gerardo and Jose LeBron LeBoy. Credit information for clips featured in this podcast can be found in the show notes at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.